What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today was perhaps, I don't want to say wildest days, but one of the most intriguing and captivating days to me of any trial I've ever watched since I started covering trials on YouTube. I couldn't believe what I was watching before my eyes. I'll try not to use unbelievable that many times in this video, but this was truly something I've never seen before, which I know is very normal for this case. But for an expert to lie so blatantly about their educational experience and then call it a mistake, or the way that I wrote it was just to mean something else. We're going to dig into exactly what he said, but I just can't believe somebody would set them out to be something that they are not in this way and this publicly. And then we've also got some DNA experts. We've got cross-examination we're going to get to, and more of what we think will happen this week. So everybody hit that like button, because we are going to jump in and we have so much to get to today. So let's get to it. All right, so we are in court for day 18. Adam Lally takes the first Commonwealth expert, and we get their education and experience and background, and they talk DNA and who can be excluded, who can't be excluded from the DNA. John O'Keefe's DNA was on the tail light, likely, with all their mumbo jumbo and words and all this stuff. Yuri Buchanan could be excluded. Proctor couldn't visibly be excluded, but then there was strong support for exclusion. And then the hair, somebody else had to do. That's the second witness. And this was the defense on cross-examination, Alan Jackson doing it. And he was explaining how, what I want to show with these two cross-examinations by Alan Jackson, not perfect, not groundbreaking, not going to win or lose you the case. But when you see defense attorneys sit over there and not ask a single question and say, we don't have to do anything and we take that seriously and we're not going to ask a single question throughout trial, these types of cross-examinations always highlight what good lawyers at least try to do. Try to poke some holes, try to explain. This isn't really as solid as you're acting like it is. And Alessi basically takes that same format and explodes it on the last witness we're going to get to. But first, let's listen to Jackson cross the very first witness and just get some little punches. I don't think it was anything groundbreaking. Some people, if he would have spent 30 minutes on it, I would have been like, whoa, not worth it. He was in and out in just a couple minutes. Let's listen to them.
Morning.
Good morning.
Thanks for joining us. A couple of questions. You mentioned, Mr. Bradford, a quantification related to both Yuri Buchanan and a known sample from former Trooper Michael Proctor. Can we go over? I'm going to ask you about the sample related to Michael Proctor. I think I heard you say 1 in 76,000, correct?
Yes.
Describe that one more time for the jurors. When you quantify that profile as it compares to the population of the Earth, for instance, what does that mean? What's the significance of 1 in 76,000?
Yes. So you need to be very careful when we're talking about statistics, because if we start to introduce different analogies to try to describe them, they start to go off the rails and we're describing things that are not actually described in the statistic.
Don't lawyers love to do that, right? Lawyers love to use analogies to make it, you could see it our way. And they're like, you can't really do that with certain statistics, so be careful.
So it makes a lot of sense to compare that to the population of the Earth, for example. However, what we're talking about here are the relative likelihoods of those two different explanations of the evidence profile. So like I said, in this case, it's 76,000 times more likely that we would observe that evidence profile if it were 3 unknown unrelated individuals, as opposed to Michael Proctor and then 2 unknown unrelated individuals.
And sometimes, Mr. Bradford, we get numbers that are just sort of mind-boggling. You said 30 zeros. What is that number again?
Nonillion.
Nonillion?
Nonillion, yes.
Y'all literally in your job, like, almost have to make up new numbers. Nonillion.
It's like, so there's a very big difference between that made up number, basically. It's not really a made up number, but that made up number and 76,000. We all can kind of feel what 76,000 feels like, right? The other number is like more people than exist in the world.
None of us have ever heard of that. That's 1 followed by 30 zeros, correct?
Correct.
As opposed to 76,000, which is 76 followed by 3 zeros.
Yes.
Much smaller number by factors of a nonillion, nearly, correct?
Correct.
So when you say that there's strong support for the exclusion of Michael Proctor in that DNA sample, you're not suggesting that he's completely excluded as a potential contributor.
Well, no, what I'm suggesting is what the numbers state, so
Right.
that it's 76,000 times more likely that it were 3 unknown unrelated individuals versus Michael Proctor and 2 unknown unrelated individuals.
Understood. So you're not excluding him. You're simply saying statistically there's strong support for exclusion, but he's not excluded as a contributor. Is that right?
I am saying that there's strong support for exclusion, yes.
Understood. With regard to that taillight sample, you were asked to compare known samples to that taillight sample, the known samples being State Trooper Yuri Buchanan and former Trooper Michael Proctor, those 2 known samples, correct?
He gets into the fact that you didn't test Albert and McCabe and Higgins, et cetera, which we've already heard him kind of say before. We're going to blow through these first 2 witnesses because obviously the bulk of the time is going to be spent on Mr. Shannon today. The next witness was another DNA witness talking about the hair. John O'Keefe. This was interesting because this is definitely the least strong any witness that's been an expert has said with any of these, numbers I've never heard before, like Jackson said. The hair, you could not exclude John O'Keefe as the sample, but also his maternal relatives. 99+% chance that it is John O'Keefe or a maternal relative. And Jackson on cross gets into the fact that mom, brother, sister, niece, nephew, all on the maternal side. We could be cooking with something here. And I thought this cross, the first cross I thought was, you got what you got. It wasn't great. 1 in 76,000 doesn't sound like great statistics for it potentially being Michael Proctor. But this one, to me, when you have multiple people who could have been in, around, or touching Karen Reed's car, was a much better argument. So we'll listen to how Jackson picked this one apart, that it's not guaranteed that this is a hair from John O'Keefe. And again, this is also a good example for lawyer strategy, right? And people wanting to know how lawyers can do this stuff. How do they argue alternative theories? Like, how can you argue that she didn't do it, but also that somebody else did it? How can you argue that it wasn't an accident, but they were hit by something, whatever. Different ways lawyers argue different theories. And this is one of those examples, right? Where Alan Jackson is arguing, and they've been arguing the whole trial, basically, that evidence is planted, and it sure seems like this magical hair was planted. But that's not all they're arguing. And if you're a defense attorney, you shouldn't just, and I've said this a million times, don't just box yourself into the conspiracy. Leave it open for reasonable doubt. And what's an argument for reasonable doubt? That this was either John O'Keefe another day touching Karen Reed's car, or even that night. You walk across and you rub your arm against the taillight as you're walking to the passenger side car to get in there for her to drive you around. Or John O'Keefe on his mother's side, his sister's children, his niece and nephew, either of their hairs, it could have been potentially. And so it leaves that open for reasonable doubt in a different way than planted evidence. It doesn't have to be planted for it to just have gotten there in the normal course of life and been a magic hair that had been on there for 2 days, 3 days. Why not? If it could have been on there where it drove all over town in the snow and in the wind.
A possible source of the hair sample. In addition, all maternally related individuals could not be excluded as being a source of the hair sample.
Another way of saying that, Mr. Miyasako, is to a reasonable degree of scientific certainty, you cannot say that hair belonged to John O'Keefe specifically, can you? Yes or no?
No, with mitochondrial DNA, you can't
Okay.
Say that it is per se an individual person, so it's more so the maternal line.
Because the hair could have come from his mom, it could have come from his maternal nephew, or anybody in his maternal line, correct?
Correct. If
Okay.
they also had access to that stuff, then yeah.
For instance, access to that stuff, meaning if his maternal nephew lived in the home with him, where the SUV was stored, it's just as reasonable that the hair came from him, correct?
Sustain.
Your analysis does not tell us when the hair got to where it was found, correct?
Correct.
Your analysis does not tell us how the hair got to where it was found, correct?
Correct.
And mitochondrial DNA does not reveal anything about the hair's color or age or texture, nothing like that.
Not on the analysis that we performed.
Okay. So for all you know, that hair could have been placed where it was found by somebody else.
Sustain.
There's the little plant that could have been placed there by somebody else. There's lots of ways it could have gotten there, right? The fact he doesn't know how it got there. It could have gotten there. It's possible that the car hit Karen Reed. We haven't gotten to the expert testimony yet. Sorry, the car hit John O'Keefe. Or could have been planted. Or it could have gotten there by somebody touching it, walking past the car, whatever it may be in everyday life. Just giving the jury other options.
You're not telling this jury how the hair got where it was ultimately found and recovered, correct?
Correct. Our testing is just based on the evidence provided to us. and the comparisons done between the two different evidence.
And in short, you can't say that the hair specifically came from John O'Keefe either, can you?
With mitochondrial DNA, I can't say that it is specific to an individual.
Okay, including John O'Keefe.
In this instance, John O'Keefe's profile was consistent with the hair sample.
That's not what my question was, Mr. Miyasako. We can go round and round. I realize that you're saying it's consistent, but it's also consistent with his nephew, right?
Correct. I can't exclude maternal relatives because mitochondrial DNA is not specific to individual, but just the maternal line.
Right.
So it's like what Jackson's trying to get him to say is, you keep using the name John O'Keefe, but we could put about 10 names there that you also can't exclude to the same whatever percentage, 99+% as John O'Keefe. And a group of those people have access to and have been in the car. And I thought it was a really good point. Doesn't mean it's not John O'Keefe's, but this is just sometimes you as the defense, the Commonwealth, and again, this is going to be very important with Mr. Shannon. Sometimes, and a good lawyer, when your witness is on the stand, you make it seem like very credible, reliable evidence that proves the fact that you want to prove. That's why I asked you guys, when every witness takes a stand, try to figure out what is the Commonwealth trying to get out of this witness. And if you can find some points, they're doing their job. The defense gets up and they have to tell you it's not so clean and easy as they try to make it seem, even with a witness that seems as simple and scientific and data-based as this witness.
So you're not saying it was John O'Keefe's hair?
I can't say whether it is, but the profile obtained from John O'Keefe is consistent with that hair sample.
You're not
But
saying it's John O'Keefe.
Mr. Jackson, let's move on.
The reason you can't say that it's John O'Keefe's hair is because it also matches everybody in his maternal line. That's what we're getting down to, correct?
yeah, with mitochondrial DNA, again, it's not unique to an individual, but their maternal lineage.
And this guy kept trying to expand on the answer, but Jackson got what he wanted. And by the way, when people were saying, oh, the defense didn't have the opportunity to speak or to object after she said there was a mistrial, let's take this as example A or exhibit A, where Judge Cannoni's like, move on, Mr. Jackson. And what is his next question? The same exact thing he was asking before. And he was right. And he got the point, and it was a better answer because he does what needs to be done for his client. And that's what they did the entire first trial and second trial. So I'll never believe that they were just too scared or didn't feel like they had the opportunity. They didn't say they were too scared, but they never had the opportunity to object. They make the opportunity to object. Good lawyers always do. Okay, so that's basically the end of that witness. And now we get to Mr. Shannon. And I don't even know where to start with your questions. There are so many good comments I'm going to put up on the screen with him. A lot of them, though, are going to come out as we get to the points in his testimony, either a direct on or cross, where they are relevant, and I will dig in to just give you an example and to start off, to make sure everybody understands. And you may be doing this. I am not. And some jurors do, right? Some jurors will say, this person has a high school education, AA, bachelor's degree, PhD, whatever, right? Double board certified, whatever you want to say, right? Stacking them on top of each other. And that's fair. Jurors do that. Lawyers know jurors do that. We want to get the best and most qualified expert. It doesn't always equate to education, though. So you can have a good expert with a high school diploma, depending on what their experience is, what they've done in life. You can have a good expert with an AA. You can have a good expert with a bachelor's. You can have a bad expert with a PhD, an MD, a JD, whatever, right? So it doesn't always, it's not a straight line. It's not linear. Just because you have more education means you're a better expert. But what you can't do is lie about your education. And knowing that while we watch this direct is such a different vibe. So we're going to watch this direct, see if, based on what Hank Brennan asks him, is he credible? And then what does the defense do to that credibility? Now, what's interesting about this is if you go back and watch, I want to say every expert, I mean, even Yuri Buchanan, they were talking about his public school education. He did not ask Mr. Shannon about his education, which leads me to believe Hank Brennan knew this was going to be a problem. And some people have sent me, if you can believe this or not, because I know a lot of you guys hate Hank Brennan. A lot of people have sent me, I think Hank Brennan is working with the feds, or I think Hank Brennan is going to throw this case. I think that's why he's doing it. And I was like, get out of here. Yeah, right. Yeah, right. After this witness, it's like, I don't actually believe it. Okay. I don't actually believe it. But after this witness, I was like, how can you put this guy on the stand? Because I also think experts can work together and rely on what somebody else in their company did, or rely more on Ian Whiffin's report. I think there were ways to hide this expert or not have him testify, but Hank Brennan wanted this guy to testify so bad. and wanted him to testify first, if you remember some of the arguments they made. But he didn't get into his education. Okay. They explained the difference between him and Dr. Welcher, what they do differently. First became involved in October of 24. Lexis data was received on December of 23. Reviewed the reports from Guarino, Whiffen, surveillance videos, and more, which we get to later. Focused on the two events. I did put, he says, sure, after every question, like a little tick. Some witnesses, some lawyers do it too. I sometimes when I get into the groove on cross, I'll say, and you did this, and you did this, and you did this. And I put and is how I string it together. So I try to guard against that. A lot of discussion about what he did with the exemplar vehicle because he couldn't get it to work properly on Karen Reed's vehicle. Power up event at 12:12. Power off event at 12:42:08. And that's the Lexus clock. And we're going to talk about time variance and all that stuff. But to me, that was strange. And Brennan, unless I missed it, did not get into that Karen Reed connected to John O'Keefe's Wi-Fi at 12:36, which I don't know how that fits into their theory at all. But 12:42 power down for the Lexus. Somebody's got to explain that to me. Is Welcher going to explain that to me? Is Alessi going to get into it on cross? He hasn't yet. They show the video of the Lexus going onto the the tow truck and the timestamps and all that. I thought that was actually good. There was some things I felt like the timestamps and the videos and the way they went through Mr. Shannon's testimony. I thought if you're with the Commonwealth, they're giving you the timestamps. They're helping you understand exactly what's happening. The graph showing the 3-point turn, the backup event with the new time is fitting in time with the kind of vague timeline. They haven't dealt with some of the issues, the 12:36 and stuff like that. But I did feel like while this witness was on the stand on direct examination, I did feel like Brennan was checking some of the boxes of making the timeline work before we hear from his accident reconstructionist. And he also explains the clock variance, which you tell me if you believe this or not, how much you believe it. Because from my perspective, I understand that there might be clock variance from like, I think somebody said the oven or the microwave clock in your kitchen. I was like, I set mine myself. Maybe some other people, like it's digital and it connects to something else. I set mine myself. So I thought that was a horrible illustration. But I get it that my cell phone doesn't always match my car or whatever it may be. Mine actually does. But some people's, I understand how that might happen. That was very confusing to me. But to me, it just seemed like it was kind of inaccurate. And we'll listen to him explain it. And then I'll kind of give you my thoughts on it.
Could you take that down, please? Now, we touched on an issue earlier. I want you to give your opinions and explain to the jury. You mentioned the word variance between different items. I don't think you used the word items. You said something else.
Sure. So that's going to be the clock variance between different devices. So in this instance, what we're referring to is the difference in the clocks of the Lexus module and an iPhone. So we would not expect those clocks to be perfectly synced. Typically what we see, and is what is generally accepted, is a clock variance of up to 60 seconds. And that is because when you think about when you're looking at your radio and you're looking at the clock, it's representing to you the hours and the minutes. It's not representing the seconds. So again, it's accurate. Its function is to be accurate to the minute, but its function is not to be accurate to the second.
And all this is fine, right? With this clock variance, I get it. And all that's fine. And he's explaining all that. I don't know. And you start to figure out, right? Because we didn't read the reports and we knew he changed the time. But I was like, why couldn't you have just testified about this? Oh yeah, this is what's in my report, but there's a clock variance. But we find out that answer when we get to cross. Because it wasn't just a simple changing this by 21 to 29 seconds. That's not all that his amended or supplemental report did. Actually, I'm going to jump ahead a little bit. When he starts talking about the 3-point turn and the backup maneuver, the two important text stream events he was focused on, it's basically all they talked about, which wasn't even in the first report, which is kind of wild that, again, I don't like, if I'm a prosecutor, I do not want jurors to think what I thought multiple times on cross, which is like, oh, that was only in the second report. It seemed like they were very similar, but it's like, no. The most important stuff he's testifying about wasn't even in his first report and came out in the middle of trial, which Alessi did a great job to point out that timeline.
because that is generally accepted that the clock variance is up to 60 seconds. And while reviewing the power on and off events and comparing that to the surveillance videos that were provided, that was consistent with what we would have expected.
Did something compel you to further your study and compare the Lexus clock information on those two text stream events, the 3-point turn and the backing maneuver, to a different device?
Yes, there was a claim of attempting to synchronize those two clocks that I believed was potentially misleading.
So
Oh, and see, I wanted to leave some of this in there. This guy accusing other people, we don't know who yet specifically, I think it's ARCA people, of being misleading and misrepresenting what data shows. Not a difference of opinion, right? Because you can have a difference of opinion as experts, but misleading, twisting, purporting something that is not true. Oh boy, and does Alessi lay it on thick at the beginning of Cross. Reality with Krista Marie, yeah, we're getting to it. When we get to Alessi Cross, that's the part where everyone's talking about it. So stay tuned, it's coming up soon.
based on reviewing that information and coming to that conclusion, did you on your own do any further study about the difference in clocks and attempt to synchronize them?
Yes, I did.
You said that you can synchronize if you have more than one device identifying a particular time. What do you mean by that?
Sure. So if we've got two devices that are recording a similar event, so let's say, for instance, a 3-point turn, if that is recorded with an iPhone, with the iPhone's clock, we can compare that event to the time that that event occurs and is recorded by the Lexus.
Were you aware of any device other than the Lexus recording that 3-point turn?
Yes, I was.
What were you aware of?
That would be an iPhone from Mr. O'Keefe.
Did you have data and information from Mr. O'Keefe's phone some time ago?
I did have partial location data from Mr. O'Keefe's iPhone.
Did you do something with his iPhone data as it relates to the Lexus clock on those two events, the 3-point turn and the backing maneuver?
I did on the 3-point turn, yes, and the backing maneuver.
Tell us what you did.
Sure. So I looked at when the 3-point turn occurred within the iPhone data and the location data in reference to that clock, and then looked at the same 3-point turn event as it was recorded from the text stream and the Lexus clock.
At some point, did you have enough data to make that full analysis?
Yes, I did.
Now, as a general concept, before we get to the 3-point turn.
So he just basically tells us this is how he updated all the times, right? But there are more claims of this being misleading and people misrepresenting things and how important that is to him. And that's why he had to do this second report. It was all because of that. Mary Claire, yeah, I noticed that while Alessi is just document after document with this guy's CV, he keeps putting him into evidence. Brennan's like, no objection. No objection. It's like, oh boy, this is not good. And again, I don't think he was very surprised by this. We'll talk about how surprised he was with the report in a minute when we find out about that. But holy cow, not good.
Analysis. Were you relying on anything beyond 0.154, that one line?
No. So that was the only thing that was being relied on at that time.
Why?
Because, again, we were initially provided a partial data set of the location.
And why didn't you seek earlier on to break this down with more specificity?
Again, because the generally accepted clock variance is up to 60 seconds, and that data was consistent with everything else we were seeing. So there was no need.
It's like, so seconds don't matter to you then, because if you could have matched it up with the phone, why didn't you if that was the more precise way to do it? That is something that stuck with me. Like even with his own explanations on direct, it's like, but you're agreeing now that this 21 to 29 seconds later is actually more precise and correct than what you put in your report as the expert, right? Are you agreeing with me now?
Need to look any further.
And what compelled you again to look further?
A claim of misinterpreting and a misleading calculation trying to adjust these clocks.
Were you given a report?
Brennan asks him again to repeat it. Now that one almost sounded like somebody accused him of misinterpreting and misusing. So I'm not even positive, but he's definitely, he wants to highlight that. He wants to highlight that.
I was not given a report. I was giving a PowerPoint presentation.
When you decided to delve deeper into this, was that on your own initiative or were you requested to do it?
That was on my own initiative.
Now, rather than simply relying on 0.154, what does breaking it down with all of the times and numbers between the green and orange do for your analysis?
Sure. So breaking it down, we can see between the green. So the green highlighted in green is position or timestamp.
We're going to jump ahead another couple minutes when he talks about, you know, what's more accurate, what's the most accurate way. So he kind of created this diagram, which I actually thought was a good demonstrative aid and visual of, where he says the 3-point turn happened with the timing of all of it. That to me is important. Sage, you know what? There were parts I felt sad for him too. Sage said, I think Brennan knew about the CV, threw him into the lion's den. I don't think it was intentional on Burgess's part. It made me cry. Maybe I am too soft. He seems to care about the work he does. And I can understand that. And like as a human being with empathy, I can understand that. Here's the problem. This guy gets paid to do this. It was an unnecessary, unforced error. And if I did something like this, I would expect this kind of scrutiny, and it's deserved, in my opinion. He didn't call him names. He didn't call him stupid. He didn't, make fun of the way he looks. He didn't make fun of the way he speaks. He didn't do any of that. It was a respectful undressing by Bob Alessi to make sure that this guy walks out bruised and beaten down by the truth to this jury. And that's what's important, because he is providing testimony he wants the jury to believe to convict somebody of a very serious crime that could put them in prison for the rest of their life.
2407, you see the heading change to a southern direction, and then the other GPS points are consistent with the vehicle moving southbound on Cedar Crest.
So the claim that you analyzed, did that actually compel you to analyze and identify a more accurate variance than you originally had?
It did.
And do you have an opinion to a reasonable degree of scientific certainty what the variance is between the clock on the defendant's Lexus on January 29, 2022 and Mr. O'Keefe's cell phone on January 29, 2022?
Yes, I do.
And to a reasonable degree of scientific certainty, what is that variance?
Objection, Your Honor.
Sustained. Need a little more screen.
Okay. After you studied timestamp 154, what did that help you do? What did you learn from that?
Sure. So after studying timestamp GPS point 154 and these further GPS positions, we are able to identify the approximate time that the 3-point turn occurred according to Mr. O'Keefe's iPhone data. So now we've got that event of when that 3-point turn occurred. Now we can compare that to the 3-point turn from the tech stream data and that running clock. Again, what we're doing is taking the power on event at 12:36.
I never understood why they didn't already do this, right? As I'm listening to him, I'm like, okay, all great and good, perfectly fine. Why would you not do this already? If you had the extra information to figure out what is most accurate when you're creating your timeline. Like Lally, not even close to doing any of this the first trial. Brennan, it seemed like, had done this, right? Abacus, sorry, Pete, but no one was a worse expert witness than Trooper. The scene told me Paul. So here's what I'll say. Paul's opinion was much worse than Shannon's opinion, but I honestly think I'd be more embarrassed if I was Shannon than Trooper Paul. I really do.
And adding the time count from the tech stream data to come up with the time of 12:23:38 in the tech stream data. So the tech stream data indicates a 3-point turn ended or a trigger event, a tech stream event ended at approximately 12:23:38. The iPhone indicates that a 3-point turn occurred between 12:23:59 and 12:24:07. So since we've got that shared event between the two devices, we can reconcile any type of clock variance. So adjusting the Lexus clock to the iPhone clock, we can calculate that clock variance.
Is this a
So to me, sounds like John O'Keefe was in the car for the 3-point turn. That's not when the hit occurred. It's the backup event, the two separate events they're trying to do here. Oof.
methodology that is commonly used in your practice?
It is.
Is it commonly used in the scientific community which you're part of?
It is.
Are there scholarly papers about this type of methodology in comparison of synchronizing clocks?
There are.
One of the papers you wrote, did that have anything to do with synchronization of clocks?
It did not have anything to do with synchronization of clocks, but it was relative to how accurate the timestamps are of events from iPhones.
And that was one of your peer-reviewed papers?
Yes, it was.
And are there scholarly journals and studies on the synchronization of clocks?
There are, yes.
Did you use that methodology in your analysis to come to arrive at an opinion about the time variance between the defendant's Lexus and Mr. O'Keefe's phone?
Yes, I did.
Okay. And do you have an opinion to a reasonable degree of scientific certainty?
Yes, I do.
And what is that opinion?
The clock variance is between 21 and 29 seconds.
If we could have number 42, please. What is this, Mr. Burgess?
Sure. So this is, if we think back to the last slide, we've identified the 3-point turn event in both data sets. So now if we want to adjust one clock to the other, we can do that. And doing that, we've identified that the variance is between 21 and 29 seconds. So we would need to adjust the Lexus clock forward by 21 to 29 seconds to synchronize it with the iPhone data. So in doing that, the end of text stream event 1162.1 goes from 12:23:38 to 12:23 between 12:23:59 and 12:24:07.
These two clocks, one on the left being the Lexus clock that reads 12:23:38 a.m., and the other clock on Mr. O'Keefe's iPhone has a different time, 12:23:59 to 12:24:07. Do you have an opinion, to a reasonable degree of scientific certainty, if these two clocks pertain to an event that's happening at the same time or a different time?
Yes. So these two clocks are, we are synchronizing these clocks to an event that is happening at the same time.
This is relative to the first text stream event, the 3-point turn. You said there was a second text stream event that you were analyzing.
Correct. There is a second text stream event.
And what is that second text stream event?
That second text stream event is a backing up maneuver.
Are you familiar with the
This is the incident, right? This is the collision, whatever they want to call it on the Commonwealth side, because depending on the report, incident, collision, different words used. God bless you. Sup from Boston. Commonwealth should throw in the towel. So somebody put that on my Twitter, the Rocky for throwing the damn towel, and it's like, that's what I was feeling. That's what I was feeling during cross. We're close to there, but I want to get out before we get to cross. I want to get out the purpose of the Commonwealth calling this witness to sync up these clocks, say what time the collision was, show how it lines up with the Lexus clock and the phone clock, and it lines up with their timeline. They don't mention the 12:36, so I don't know how they're going to explain that. They need to explain that to the jurors, but I'm trying to be even-handed here with what I'm showing the purpose of this witness is, and this is all before we get to what Alessi does to him. And some people haven't watched the cross, so tell me what you think. Is this making sense? Are they trying to line it up and starting to line it up for you as far as how the timeline goes and showing where the car went at what time?
time frame on the Lexus clock relative to that second text stream event?
Yes, I am.
And what is that time frame?
So it is approximately 19 minutes from the ignition on.
And do you know what time that is on the Lexus clock?
19 minutes from the ignition on. That's what he says. So 12:12 to 12:31, right, is 19 minutes.
Yes, I do.
With the court's permission?
Yes.
End of that text stream event
That text
is going to be 12:31:43 is going to be the end of that text stream event.
stream event, by the way, when it captures data, what window of data does it capture when there's a text stream event or a triggering event?
Sure. So when the trigger occurs, it captures data 5 seconds before and 5 seconds after the trigger.
What if the event is less than 10 seconds?
So if it's less than 10 seconds, it would capture the entire event. If it's more than 10 seconds, it would only capture a partial snapshot of that event.
And so when you talk about the data for the backing event, is that the 10-second window you're speaking of?
Yes, that is that 10-second window.
Does that have anything to do with defining the length of the actual event?
No, it does not.
When you looked at the time from the Lexus clock regarding that backing event, did you do an analysis of John O'Keefe's phone considering the variance that you identified?
Yes, I did. So I applied the same variance to that second text stream event.
When you apply that variance between the Lexus clock and Mr. O'Keefe's phone, what is could I turn to 43, please? What is the time of that event if we're referring to Mr. O'Keefe's phone?
Sure. So the time of that event with the clock variance adjusted is 12:32:04 to between 12:32:04 and 12:32:12.
And do you have an opinion to a reasonable degree of scientific certainty as to the accuracy of that time from Mr. O'Keefe's phone considering the variance?
Yes, I do.
And what is your opinion?
And the opinion is that the second text stream event ends between 12:32:04 and 12:32:12.
When you say text stream event, that's the 10-second window?
Correct. That's the 10-second window.
Does that necessarily include the entire event?
No, it does not.
The graph on the bottom, what does that show us? It looks a little bit overwritten.
Yeah. So that graph is a timeline representation of the text stream event ending, being adjusted with the 12:32:04 to 12:32:12 in comparison with the last lock event that is recorded by Mr. O'Keefe's phone at 12:32:09.
Your analysis relative to the data that you obtained from the SD card, is your analysis and opinions separate from the other information you looked at that corroborated or supported your analysis?
Yes, they are.
And Mary C., it's not just, you're right, defense lawyers and money, but even their teams, right? And the people doing the research and looking into things, because we find out They're doing a lot of things behind the scenes, and it's really affecting this case and their presentation and defense in this case. Charlie, a lot of the objections today, I felt like, especially with this witness, were like foundation. Does he know about that? Can he answer that? Ask it differently, meaning you haven't laid enough foundation yet, or you're leading. So a lot of it had to do with that. Like they had to do something before they could get to the question they want to ask, because so many times both lawyers ended up getting to the point they wanted to, but they had to ask some foundational questions first.
I have no further questions.
All right. So that was the end of his direct. That is the information Hank Brennan wanted to get out of this witness. And then the bloodbath comes and cross. Everybody hit the like button. If you haven't already, like the video, because now we are going to get to cross, and I'm going to answer so many of your questions have to do with what came out during cross, and I'm going to get to every single one of the questions that I can. When I say every single one that time allows me to get to, okay? So first, it talks about forensics, something suitable for the law, science, attempt the truth. You must be accurate, detailed, methodology, unbiased, truthful, reliable, defines confirmation bias. Before you do your testing, what do you do, and what do you make sure that you don't have confirmation bias? So he sets it all up, of course, and how important it is to be accurate, reliable, credible, and truthful. Everybody on the planet would agree with that, right? Everybody would agree with that. But Alessi is setting each bowling pin up to literally knock them down. Because somebody said, gosh, I wish I could find all of these. I got to find it. It was just too good. It was too perfect. Here it is. Kevin, from the opening of Cross, I thought, he is going somewhere. And then when he said, let's discuss your education, oh crap, it's about to go down. I had seen some stuff floating around Twitter, but I never really want to get into it until it's confirmed and comes out in court. And when Hank Brennan wasn't even objecting to Alessi's question on his education, I was like, I guess I can say this is legit. And that's exactly how I felt. He started on down one road and I was like, oh, maybe he's going there. But right when he said, let's talk about your education, which Mr. Brennan did not, he says, you must be truthful about your credentials, correct? Yes. People rely on them. Correct. Colleagues rely on them. Yes. Clients rely on them. It's important your CV is correct because that's the ethical thing to do. And he keeps answering yes. He keeps saying stuff like, the witness kept saying stuff like, depending on the context and things there. It's like, context? It's like, so there's a contextual example of when you can lie? Of course you wouldn't agree with that. So he, again, just sets him up. And he talks about November of 2024, Bachelor of Science. It says you're still pursuing. And I thought that was such an excellent spot to start because every other time you're wrong about what you say about your bachelor's degree, you know, Mr. Shannon, that you can just put in there, what is it? Currently pursuing, and you don't need to put a date if you haven't gotten it. That's the point of the date. Or people say JD candidate, 2026, whatever it may be. So we all know what that means. I cannot imagine if somebody that worked here, if a lawyer worked here, lied about getting their JD, what I would do. First off, the trouble I could get in for having a lawyer practice law without a degree. Obviously, we check those things. But I'm just saying, like, how serious of a problem this is. And then April of 25 still mentions he has not yet earned his bachelor degree. And as he still sits here today, he does not possess a bachelor degree. And Mr. Shannon was probably thinking, okay, yes, I don't have my bachelor's degree. I only have an AA. Let's move on now. But that's not what they were doing. Aperture updated man Shannon CV again, not for expert designation. That doesn't surprise me. Anybody watching this, I feel bad for this guy. That's my initial thought. It's like, who would ever hire him again? He says he works on car accident cases. He says he works for law firms and insurance companies. It sounds like he's a defense expert mostly and working for insurance companies, which doesn't surprise me. But even they, I would think, would not want to work with him anymore. Christy Gagnon. Peter, Have you had jurors completely change their mind about how they were going to vote because of witnesses like this? Yes, absolutely. There are witnesses that are so catastrophic to one side or the other that it can change a juror's votes. Not always. And again, when parties testify, meaning plaintiff, defendant, they tend to be the most important witness. Red, is this not problematic for Brennan? Brennan lied to the court too in offering this man's supposed education level in open court this morning. I do not think Brennan talked about his education experience, and I definitely don't think Brennan elicited a question that, or elicited an answer that he had his bachelor's degree. I went back and listened, and I do not remember that ever coming out. So if it did, let me know. Peter, how do we feel about lying about our education, copy and pasting? Good Lord, this was crazy. So lying about your education should be a cardinal sin and usually is. Copy and pasting shows laziness, is something you can impeach with. I will just tell you, I have had multiple neurospine and neurobrain surgeons copy and paste on their reports, board certified radiologists, forensic radiologists who I've cross-examined, and they copy and paste the same findings, the same initial stuff on report after report. And these people make millions of dollars in testifying for insurance companies. So the copy and pasting is probably more similar than you think. Peter, have you ever seen something like this? Not to this level, where this guy got so far, definitely not to this level where it felt like Brennan knew about these issues with his education and still put him on the stand and let him get cross-examined. I have had situations where experts lie and they get removed. Absolutely. I've had issues where, like, we've had an issue before where an expert posted some stuff on social media that was going to be a major problem. We got a new expert. Did Hank Brennan commit perjury to Bev about being surprised about the report? Bev knew it was a lie, covered it up, and SB violating the sequestration order. So he says he didn't watch any of the testimony, and we are going to get to what Brennan knew and when he knew it and whether or not I think he lied to the court. Okay? Suborning perjury. Did Brennan say he graduated from Alabama? University of Alabama, Birmingham? Did he? I don't think he did. So I don't think he suborned perjury myself. All right, let's listen. This is, the Rocky throwing the towel. This is the, Homer Simpson backing up into the bush. This is just every cringe-worthy, uncomfortable, crawl out of your skin. And you guys get to look at my face as we watch it again. I'm glad you weren't looking the first time we watched because I can't imagine the expressions I was making, but let's take a listen here. Hit a little.
Your Honor, may I have this marked as next up? We're just giving you Exhibit DB.
Yes, I do.
And indeed, that is the bio page that's published on Aperture's website, correct?
That is what it appears to be, yes.
Now, I would like you, sir, to turn to page 2 of that document.
Okay.
And I'd like to turn your focus to the bottom of education heading. It states, am I correct, sir, BS, Mathematics, and Business Administration. Is that correct?
It does state that, yes.
And there is no qualification that it's currently pending. It states BS in Mathematics and Business Administration, correct?
That's what it states there, yes.
And you do not have a Bachelor of Science in Mathematics and Business Administration, do you?
No, I do not.
I mean, even just that is catastrophic if he was done there and he moved on, but it just gets so much worse.
And if you click on the hyperlink for your CV on that same website, do you know where that hyperlink takes you?
No, I do not.
To any member of the public reading this, including prosecutor, a defense attorney, a judge, or a jury, that represents that you received your Bachelor of Science in Mathematics and Business Administration, does it not? Objection.
That's sustained.
Don't worry. He's going to be able to get into it. If Jay was in the car when she turned, it makes less sense. If she backed up and hit him, he would be in the street, not in the yard. Or John O'Keefe wasn't in the car for the 3-point turn. What? Here's the point. The more confusion that comes out from all these witnesses and then the lack of clarity and details from the Commonwealth, from the data, which they said would prove their case, all are issues for the Commonwealth that they have to deal with.
Now, if you continue on to your photograph, Are you familiar with Aperture's website that speaks about you and presents you generally?
Vaguely, yes.
Are you aware that Aperture has two hyperlinks, one that says CV and one says LinkedIn? Are you aware of that?
Yes, I am now.
And LinkedIn is a professional networking platform designed for career and business professionals to connect, share content, find jobs, etc. Is that a fair description of LinkedIn?
Yes, it is.
And could we also conclude that it's a professional networking platform, especially for private sector firms like Aperture, that's used to attract clients or potential clients?
Yes, correct.
And potential clients include, for example, the Commonwealth of the state.
Now, you could say this has nothing to do with the case, but this has to do with character, credibility, truthfulness. Like, is it really just it was a mistake or a misunderstanding? I was just putting this on there to, let everybody know I was going to be getting my degree. Or did you lie to get clients? Did you lie to make money? And if you're willing to lie to make money, are you sitting there making money as an expert testifying today and lying to do whatever you're going to say to make sure your client wins so you can get more money, like you lied on your resume so all these people would hire you and get you more money? That's what he's trying to set up with this. That's what he's trying to explain. Susie said, this witness admitted to working for insurance companies. Can any claims/cases he's worked on investigated be reopened? Can he be sued by the companies he's worked for lying about his credentials? So if he's gone to trial and he's lied under oath, that could be an issue. But if he's just worked on your case and provided information to insurance companies, it's bad. He could get fired, but doesn't necessarily mean the claim will get overturned or reopened or things like that. Not necessarily.
Of Massachusetts, correct?
Correct.
And indeed, the Commonwealth is no longer, if you will, an attracted client, but it's an actual client of Aperture, and you correct?
Correct.
And that's the status of the relationship here. Aperture is a client of the Commonwealth of Massachusetts in this case, right?
Correct.
So is it fair to say that your CV, especially when it's published on a LinkedIn or published on a website, is something that is published to intend to have, especially if you're in the private sector, have clients view and retain your services? That's a hope and an expectation, correct?
Yes, that is part of it.
Now, when you look at that document, when you click on, if you were to be in your office, and let's see if you're familiar with this, you click on your LinkedIn on Aperture's page, that would ordinarily take you directly to your professional LinkedIn account, correct? Isn't that what the links are there for?
Yes, I would expect so.
Are you notified when someone electronically accesses your LinkedIn account?
Not accesses, no.
So this was another part where I was like, what? Like, this is bad. This is bad. And just like people are saying, by the way, with these questions right here we're about to listen to, if one of the first comments I put up about it says no longer available for expert hire, if that change has really been made on LinkedIn, you better believe Tuesday, May 20th, he is going to get up there, and unless he's going to ask him about that. That would be my guess. Do you know why that happened in the middle of my cross yesterday?
No. Are you referring to viewing?
Yes, that's a better
sorry,
verb,
yeah.
viewing. Yes.
Yes.
So you're notified. Were you notified within the last 72 hours that someone from the defense accessed your publicly available or viewed your publicly available LinkedIn account?
No, I was not aware.
Because you can see that stuff. It does say Mark Lyon viewed your profile. Mark, there's just too many. I know I'm going to start breaking and cracking from some of these comments, but I'm doing my best not to. But yeah, you can actually see that. And we all know it. And he agreed with it. And he's like, did you see that somebody from the defense accessed that? Because they were looking to see about this whole resume issue we're talking about. Did you actually graduate in 2016 to 18 or 2022? Did you actually, or did you just put it up there? And so the defense looked, they viewed his profile. He admits that he gets notified. He says he didn't see that, but what does he do?
Are you aware that within the last 72 hours, that hyperlink on Aperture's official website was disabled?
No, I was not aware.
Are you aware that now if you try to go on that link, that you can't, that it's disabled?
No, I'm not aware of that.
Do you know whether anyone from Aperture directed someone within Aperture to disable your LinkedIn account within the last 72 hours?
No, I'm not.
Have you spoken to anybody at Aperture about your LinkedIn account?
No, I have not.
Well, my guess is they're watching, right? My guess is they're watching. So what you're saying is you actually have a degree. So there were some people on Twitter. You know how nice everybody on Twitter always is. By the way, Twitter was wild today with the memes and stuff. It was just crazy. but somebody was like, yeah, whatever, your time is coming or your career's over, you pedo lawyer or something like that. And I was like, or nepto lawyer, maybe nepto, not pedo. Yeah, that was probably bad. Nepto lawyer, whatever. And I literally wanted to like quote tweet it and be like, at least me and daddy went to college. You know, it's like, that's what I wanted to say, because it's like people coming after you for saying that this is a big deal, that this guy lied about his college education is not the same thing about anything you want to say about anybody else with their job. Okay. Well, however you think somebody's got a job or have a platform or has a YouTube channel or whatever you want to say, like no real lawyer can have a YouTube channel. Sure. Go crazy. But because of the college education, posting a date that you graduated, that's not like an accident. This guy tries to say so many things are misinterpretations or misunderstandings. And it's like, that's not what that is, man. That's not the same way to look at it. Yes. Do you know what that means, Mr. Shannon? No, you don't, do you? Okay. How many jurors do you think went home and looked that up? Yeah, I know. Big difference. Big difference. I'm sure that's going to be the thing everybody takes away here. All right, actually, I think I'm going to jump ahead a little bit. Then they get to a screenshot of his LinkedIn account. We're going to jump ahead a little bit because there's just so much. I mean, there's so many things. Somebody said, love how Alessi set this up. It was brutal. He's going to catch a charge for this beatdown. Yeah, it's like, you want to see a body? That's what I was thinking when I was watching this too. So many inappropriate things because of how bad this was. So bad. I mean, this was just so bad. And I don't even care. Like, if this happened to a defense expert, you should absolutely feel the same way, even if you think Karen Reed is innocent. If a defense expert gets up there and lies about their education on LinkedIn and on their CV, you should do the exact same thing. And you better believe I will do the same thing. I can promise you that.
Have any reason to believe that exhibit WW is not on your LinkedIn page online as we sit here today?
No, I don't.
Your Honor, I move exhibit WW into evidence.
No objection.
Not very many objections as he entered this stuff. That was something I definitely noticed.
Exhibit 186.
Thank you.
I would like to turn your attention to the printout of your personal LinkedIn page and go right to the second page, bottom. And under education, it says University of Alabama at Birmingham. It's got a little UAB acronym there. And it says Bachelor of Science, B period, S period, comma, Applied Mathematics and Scientific Computation, 2016-2018. Do you see that, sir?
Yes, I do.
And the way he answers that, yes, I do. I'd be like, yeah, that's just wrong. It's just wrong. That's when I was planning on going, but I didn't. Like, I would show some remorse. Like, I blew it. I blew this. He does not do that. He's like, yeah, I see it on there. What's the big deal? By the way, I'm like sweating in here. I think the AC may have turned off. What time is it? No, it's not 5:30. Okay. So also, Sage, I don't think this is Hank Brennan's fault. I really don't. I mean, yeah, did he put him out there and let this happen? Sure, but he didn't make this guy's resume. He didn't go to college for this guy. You know, like you got to take some responsibility as an adult. To me, this is all on Mr. Shannon.
That's not correct, is it?
No, it's not correct.
And you do not hold a BS in a Bachelor of Science in Applied Mathematics and Scientific Computation from the University of Alabama at Birmingham, do you?
I do not. And that would have been at that time an expected graduation date.
You indicate on a resume if it's an expected graduation date. You indicate that. That's not how you do it. And everybody knows it. He's old enough to know that. And he works for a real company.
So it would be expected, you state.
Correct.
I'm not saying, okay, hold on. First off, let's just calm down. I'm not saying Brennan's not to blame for calling him as a witness. Brennan has to eat this problem as a witness. But what I'm saying is the embarrassment of getting embarrassed and impeached and his credibility crushed on the stand lies with this guy, because he's the one that worked on his CV and his resume, not Brennan. Brennan is to blame for choosing him as an expert, and he's going to have to deal with the repercussions when the jury looks at this. No doubt about it. No doubt about it.
It would be another word for, another word currently pursuing? Is that similar to expecting?
Sure, that could be similar.
But you know how to put currently pursuing down, don't you, sir? Because you did it on the first few CVs.
And that's why you start with that question if you're a lessee, and he did, and he set it up beautifully.
But you don't have it on your LinkedIn page, am I correct?
Correct. That's probably because obviously that has not been updated in quite some time.
And you said you get notifications when people access your LinkedIn page, correct?
I get selective notifications when people view my LinkedIn page.
So you know people are
Selective notifications.
looking at your LinkedIn page. You know people are looking at your education. And you have down here 2016 to 2018. So that time period is 7 years old from 2018, yet you use the 2016 to 2018 on your LinkedIn page, correct?
Correct. With the caveat.
We find out that he started in 2008. So what exactly is, and unless he didn't beat a dead horse, but like what exactly was 2016 to 18? Because it almost sounds like those are the years I was in college at UAB. Right? It definitely didn't seem like what does that mean? Like you're going to graduate sometime between 2016 and 18. And by the way, if it's out of date, you better go update it. You can't have incorrect. They can be out of date, meaning like I haven't updated my newest job. Fine. But when you're out of date, usually it means something is behind. Like I worked at the Lofts Trago Stars and Tragos until 2023. It's like, oh, I just haven't updated it to say 2025. That's what out of date means. Not I worked for the president of the United States from 2012 to 2013. And it's like, I never actually did that, but I just haven't gone and updated my resume yet. It's not how it works. It's not how it works.
Caveat that my understanding is people look at your post, not specifically the profile information.
No.
Oh, so you believe?
No, it says this person has viewed your profile. Nurse Kim's has looked at your profile. That's what it says. Siobhan, Peter, be honest, no mendacity. Were y'all lawyers all screaming and running around your office during this? Your poker face is unmatched, sir. No, pretty much just me walking in my dad's office saying, so Alessi hasn't even gotten to the timeline yet, but listen to this. And he's like, how is that possible? It's like, how do you pick that? You have the resources of the state government. You can pick any expert you want. You have unlimited resources basically. And this is what you end up with. It's crazy. And everybody wants to work for the DA, right? All these experts, it's so much easier to work. It's hard. People hate you when you work for the defense, as we're seeing in this case.
You know, apparently when people are looking at it and what they look at?
No, that's not what I'm saying. I'm saying generally.
Generally.
Correct.
But you don't know who's looking at the education section on your LinkedIn page and relying upon what is represented here, that you have a Bachelor of Science in Applied Mathematics and Scientific Computation from the University of Alabama at Birmingham.
Not from the LinkedIn page. Yeah, just independently of the LinkedIn page, yes.
No, that's good. And Fire on Acid said all of the CVs on Aperture experts say not for expert designation. Okay, good. Thank you. Unless he just crushes the mic with his papers.
And as you sit here today, that page is still live on your LinkedIn, correct?
Correct.
That's brutal.
So a key aspect of your credentials, whether or not you have obtained a Bachelor of Science, is incorrect in more than one document that I presented here today, correct?
No, I would not agree with that.
Well, it's incorrect in this one, correct?
Correct.
And
We're going to jump ahead just a little bit as he digs more into this.
rated them with them to make sure it was right to the best of your ability, correct?
Correct.
If you can look at the highlighted portion, sir, under education.
There's no well, I understand what you're talking about. There's no highlighted
I'm
portion.
sorry, let's strike that. If you look under education, the first line, it says in the right underneath BGS. Do you see that, sir?
I do, yes.
And then to the right, it says Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, 2022. Did I read that correct?
Yes, you did.
Again, yes, you did. I'd be like, brother, I don't know what to tell you. It's dead wrong. Right? Just eat it. Like this just makes me feel like he doesn't even care. Like he doesn't even care. He's like, yeah, that's wrong on there. So what? It's like, what? Mark, can you imagine? Well, he's still pursuing, right? He's still pursuing. So maybe not down the drain. Maybe he'll get it one day soon.
And up in the upper left-hand corner, there's a photograph.
By the way, saying something's out of date from 2016, 2018, or 2022, it's like, why did you ever write that down? Why would you ever put that in there if it was wrong the day you put it in there? Like you didn't graduate the day you put it in there, it was wrong. So it's not like updating. But after we laugh, curing all of his cases, I mean, I would definitely bring it up, but I don't think it's going to be, if he didn't lie under oath about his education and his CV was wrong and he worked on the case, I don't know if it's going to be material to too many cases. Every time this guy ever testifies in the future, if it ever happens again, and it's kind of sad, he's testified in like 4 or 5 different states. He's worked at this company for 10 years. This is really the only time this has come up, which I find just mind-boggling.
Yes, there is.
Is that you, sir, in the photograph?
Yes, it is.
And in the spelling of your name, Shannon, that's with one N, correct?
Correct. Yes.
And so that is not only you in the photograph, that's the spelling of your name with one N, correct?
Correct.
And that's the correct spelling of your first name with one N, correct?
Yes. It
So
is.
that's definitely you represented in this document, correct?
Yes, that is correct.
Now let's look at the first line that relates to education. It states Bachelor's of General Science in Mathematics and Business Administration, correct?
That is what it states. Yes.
And the date is 2022, correct?
Correct.
So this document represents that you received your Bachelor's of General Science in Mathematics and Business Administration in 2022, correct?
That is what it states, but there are a number of errors in that. Yes.
Correct. So let's go on. So
There you go. At least he admits it there. There are a number of errors here. Well, let's talk about those errors and let's hit the like button because we've hit the hour mark. We still have quite a ways to go here. So make sure you guys all hit the like button now because we're going to dig in here to this devastating cross. I mean, it just keeps getting worse. And it doesn't end at the end of the day today. Spoiler alert. There's going to be more tomorrow.
this is the third example. Am I correct, sir? Well, let me, may I approach, Your Honor?
Yes.
Your Honor, at this time, I offer Exhibit XX into evidence.
No objection.
187.
Oh, Siobhan, that's brutal. That's what's on their site. Oof. Stephen Lee, it wouldn't be stricken. Now, theoretically, if she would have let him voir dire, which I know a lot of your comments are about, he could have been potentially stricken as an expert if the judge found he needed that education and didn't have it to be an expert. But I think he still probably could have been qualified as an expert with his experience and even with an AA, because we talked about this. You don't have to have a college degree. You don't have to have a master's to be an expert in certain areas. So it's like you didn't even have to lie about this. We all know why you did, but you didn't even have to. And I feel confident saying it's a lie since it was documented in paper, publicly facing, and not true. So it was either a lie by omission or commission. I don't forget. I feel like I've mentioned that lots of times. 8 jurors last trial were guilty. Absolutely. And there very well could be guilty jurors on this, jurors voting guilty on this jury right now. Will there be 12 is the question.
Sir, is Exhibit 187 a CV that is linked directly from Aperture's website?
I do not know. I would have to look and check that.
So as you sit here today, you are not able to state whether that CV is linked directly from Aperture's website.
Correct.
So this is a third example of a document that incorrectly states that you have a Bachelor of Science when you do not possess that degree, correct?
It has errors or outdated information. Correct.
Well, when you
Outdated, brother. Outdated means something that used to be true but isn't true any longer or has changed. You have never gotten your bachelor's from UAB. So that is not outdated. That is just old, wrong information.
say outdated, how is it that you can call a date outdated next to something that you don't possess?
I don't understand your question.
Well, you just use the phrase either incorrect or outdated. I'm trying to understand your statement that it's
Sure. So
outdated. Isn't it either you have a Bachelor of Science degree or you don't? Isn't
I have represented I do not have a bachelor's degree.
correct? But in here, it's represented that you do, correct?
Yes, it is
All
an
right.
error. Yes.
So let's look at what the name is that are on these documents. It says Bachelor of General Science in Mathematics and Business Administration. Do you see that, sir?
I do.
Are you aware that there's no degree at the University of Alabama, Birmingham, called a Bachelor of General Science in Mathematics and Business Administration?
What? So you didn't even like falsify the CV appropriately? I mean, this is just so bad. It's so bad. And I try to give people grace and see it from their side and like, okay, and we're going to talk about the Hank Brennan situation. What did he know? When did he know it? Was he honest with the court when he said he was surprised? And people probably aren't going to like the way I see that and the way I think that would be proven and borne out in future discussions. I do not see a different, nicer, better, more gracious way to view what this guy did multiple different ways on his resume. I think he said he's been doing this kind of work, Nicole, for 10 years.
Yes, I am. And that is one of the errors I've identified.
So
So he did know that. He did know that that general science and business administration degree doesn't even exist at UAB, the school that you didn't graduate from. It's brutal.
you would agree that there's not even a degree called Bachelor of General Science in Mathematics and Business Administration offered at the University of Alabama, correct?
Correct. That should be back.
I mean, that's brutal. John, yeah, he didn't just save it for this guy. He's going to get to Welcher too, because by putting this guy up, it's almost like fruit of the poisonous tree. What he touched, whoever used what he touched, their credibility is sunk as well.
Bachelor of General Studies with minor in Mathematics and Business Administration.
And what you just articulated, you do not possess as you sit here today, correct?
That is correct.
What you possess
He's like, oh, well, what they do have is this. He's like, well, you don't have that either. No, I don't.
is an associate's degree, correct?
Correct.
And when did you obtain that associate's degree?
So that would have been 2015.
So then how is 2016 to 2018, like, you thought that's when you were going to end up getting it? Wait, I thought he said he started getting his bachelor's in 2008. So you started getting your bachelor's in 2008. So maybe that's the 4-year track he was doing, and it took him till 2015 to get his AA. And then he's been working on the last 2 years after that. I don't know. It's just, in my opinion, his opinion is still better than Trooper Paul, makes more sense than Trooper Paul. I think he understands his line of work much better than Trooper Paul. I do feel that way about him. I don't think this guy's like a moron. I don't think he has no clue what he's talking about. Like, I think he was able to explain what he thinks, why he thinks, and the backup for that a billion times better than Trooper Paul. But I got to say, I think just as many jurors are going to look at this guy and be like, whoa, brother, I don't even know if your name, I don't even know if I can trust that, right? Like, I wouldn't trust you with my bike, people say. And that's tough. Yeah, this is not a good look for, it's not a good day for our aperture. I'm going to jump ahead a little bit to, oh, he's actually, I should play this. Dang it. There's just so much. There's just so much. I was going to skip this part, but it's just so good.
Commonwealth hired you to perform a new data acquisition from the infotainment and telematics system of Ms. Reed's Lexus SUV, correct?
That is correct.
And in your October 10, 2024 report, you outlined a proposal for attempting to extract additional data from the telematics and infotainment modules, correct?
Correct. With the caveat, it's not a report. It is a proposed protocol.
Which is like literally the same thing as a report, but whatever. He wants to play semantics.
So we'll call it a proposal.
Maybe I shouldn't say literally the same thing, but it's for purposes of this discussion, the same thing.
In that proposal, you explain why, in your opinion, you believed an additional data acquisition was necessary based on your words, education, training, and background, correct?
That is correct.
When you prepared your proposal, you had access to the manufacturing specifications of the chips in question, correct?
I did.
You were under no critical deadlines to get the work done, correct?
Correct.
In your initial October 10, 2024 report, you explained that you believed the data acquisition was incomplete because, in your opinion, based on your education, again, your words, training, and experience.
Did you catch that? Unless he said education, in your words, he's like, man, brother, I'm not trying to harp on it, but you did say in your education experience, which does not include a bachelor's degree.
Acquisition was incomplete because, in your opinion, based on your education, again, your words, training, and experience, the download of the acquisition was less than the chip's storage capacity, correct?
That is correct.
And converting megabytes, B-Y-T-E-S, to megabits, B-I-T-S, and gigabytes to gigabits is a basic digital forensic concept.
All right, we don't need to get into all those definitions. He screwed it up. He admits that he screwed it up. He said it was a misinterpretation or a misunderstanding. And he's like, you got it wrong. That's a mistake. Not the woman you blamed it on. You made the mistake. And we're going to listen to a little bit more of that. Joe Flipperhead, what's up, Peter? Can you explain the requirements of testifying to a reasonable degree of scientific certainty? So it's basically something that people in the field of science, just like a reasonable degree of medical certainty, or people in the medical field can say, I'm pretty certain about this. But generally speaking, it's supposed to be that it's something that is well established either in the medical field or scientific field on those principles, reliable methods, the evidence, and you are confident that what you say is in fact correct. That's basically the best I can do, because it's like, it's not 99% sure. It's not something like that. It's just basically putting all that together. Are you pretty certain of your opinion? That's generally what we're asking these experts.
Micron, and I'm going to have to give an alphanumeric number because I know in digital forensics it's important to be precise and accurate, so bear with me, sir. You stated in your report that the Micron 29F2G08 ABAEA is a 2 gigabyte chip, and that the acquisition should have been 2 gigabytes, but was incomplete because it was only 264 MB in size, correct?
That is correct.
And the
So this is, again, now Alessi's getting to the technical stuff he just got wrong. John said, some might dislike this expert, but he wasn't embarrassing. He answered Alessi's questions and stayed calm. I agree, he stayed calm. In my opinion, just playing devil's advocate, I'll take you to the floor with this one, John. I disagree with you. If you are an expert, a scientific expert, and you got this stuff wrong that he gets wrong, again, sounded more competent. I don't think he's like a buffoon, like maybe I thought Trooper Paul was, but he messed up a lot. So he wasn't very good at what he was supposed to be doing in this case, number one, even though I thought on direct, he did a good job of laying it out. And if we just saw direct, I think he would have been fine. Even on direct, I thought Trooper Paul was not good, right? And on redirect. So I get what you're saying there if you're comparing him to Trooper Paul, but the educational stuff and the stuff he messed up was embarrassing to me. And I'm just telling you, as somebody who has an education that is postgraduate education, could be considered an expert on certain things, I would be so embarrassed if this happened to me. I'll just put it that way. Not that I think I'm an expert or so smart or anything like that. Okay, save it. Lots of smarter people than me. Definitely Bob Alessi, considerably smarter. This guy's probably smarter than me, right? But it's like, this is embarrassing, and you can't do stuff like this, and you create your own problem when you do what he did.
Micron, and I'm just going to refer back to the number to not repeat it, the long alphanumeric number is a 2 gigabit flash memory component, not a 2 gigabyte flash memory component, as you incorrectly stated in your protocol, correct?
Yes, that is correct.
So 2 gigabytes is equal to 250 megabytes, correct?
Correct.
And that suggests that all available data was successfully retrieved during the first acquisition by Ms. Gaffney, correct?
From those chips, yes.
From those chips. I'm correct, right?
Yes.
Your opinion was again incorrect and was based on a misunderstanding of gigabits and gigabytes, correct?
A misinterpretation, correct.
A misinterpretation in layperson's terms.
Like he keeps throwing out this stuff like misinterpretation. Alex, I agree. That could have been the case, right? But it's pretty hard for her phone to connect to the Wi-Fi if she's not in the driveway. And none of these explanations are going to help the Commonwealth, right? And they haven't addressed it, which they have to. That is their job.
You got that wrong also.
It was an error, yes.
Did you have that protocol peer reviewed, sir?
No, I did not.
Was it peer reviewed by anybody at Aperture?
No, it was not.
Did you have a supervisor review that protocol before you filed it with the court?
No, sir.
You submitted your proposal based on your education, background, and experience, correct?
Correct.
Turns
Based on your education. As many times as Alessi can say that, he's going to.
out that the entire foundation of your proposal was based on a fundamental misinterpretation of the difference between a computer bit and a computer byte, correct?
No, not the entire thing. No.
Well, certainly a part of it was, correct, sir?
Correct. Partial.
You got conversions wrong with respect to analyzing 3 different chips, correct?
Correct.
And since you wrote that, have you learned the difference between a bit and a byte?
I've always known the difference between a bit and a byte. Yes.
You learned that in this case from
I always say not to go into the experts' expertise with them because they usually know more than you and are smarter than you. I have a feeling that Alessi doesn't necessarily have to play by that rule.
reading the affidavit of an expert for the defense who pointed out those errors before you submitted your supplemental report. Isn't that correct?
So you didn't even figure this out until, once again, we, the defense, had to point it out to you. And that's going to be a common theme. And Mick, that could be, you could represent multiple jurors if they have, again, advanced degrees in work skilled positions. Oof. Multiple people have been saying this. Oh, Forrest Dump. It's just too good. It's too good.
Correct.
I would have to go back and look at the timing on that. I believe I submitted the supplemental before the protocol from the other expert.
No, you
Are you
didn't.
certain of that?
I'm not certain of that.
Unless he's like, are you sure? And he's like, I'm not certain. I just kind of hope so.
Isn't it the case that the expert for the defense submitted his affidavit before you submitted your supplemental report?
Objection.
Do you know that?
I do not know that.
You don't know one way or another.
Correct.
And that person
All right, we're going to jump ahead a little bit. He does mention Trooper Paul in his report and the reconstruction team at MSP. Do you know who he is? No. And he talks about, or do you know that he knows who he is, I think, but he doesn't know if he's still on the team or still working as a reconstruction expert on this case. That indicates to me that we are going to hear Trooper Paul's name a lot throughout this reconstruction theory, which I'm very glad about, and the defense should absolutely do. It is huge for them. He did review Garino's testimony. He only skimmed it, though, and didn't get into the information that Alessi wanted to get into. Tully is the one that handed him the infotainment system, which I thought was important to highlight. They were unable to install it and use it in Miss Reed's vehicle. It would not respond as expected. Then he gets into the initial report. And the initial report does not discuss collision, does not indicate the timing of the text stream events, but the new report does. And he says, wasn't your goal the timeline? Yes. And Welcher needed it. Correct. But he's like, I don't really know what Welcher did. And then he said, oh, I misspoke. Yeah, okay. Welcher needed it. So he kind of went back and forth on that. And now we're going to get into who knew what when you did this updated report in the middle of trial, the timeline that we knew was coming. I thought might be in the beginning. It was more at the end of the day today. Before we get there, I'm going to blow through some questions here because you guys got a lot of questions. Did you see your cameo in the Karen Reed AI video? My favorite by far. I did not. Well, I saw one. Somebody sent me another one I couldn't watch because I don't have TikTok myself, but send it to me and I'll watch it. Idiot Wind. Is Bev going to make findings of material misrepresentation to the court with Brennan's behalf with that out of the blue and not asking him anything at all on Burgess's education? Not the education part, but the out of the blue. Let's wait and we're going to watch what Burgess says together here. Ronell. Hi, Peter. Bet HB wishes the judge agreed to a voir dire session with the expert. Do you think Hank Brennan expected this scrutiny on the qualifications? You'd have to be a moron not to. Any lawyer, like Hank Brennan, would do the same thing. Amelia, why isn't the DA Morrissey prosecuting this case if they weren't conflicted off? How is it ethical to hire a special prosecutor? That's how the rules are in this case and the decisions that were made before I ever started covering the case. Matt, Pete St. Pete, I'm baffled after the obvious ineptitude of the Commonwealth why the judge doesn't simply dismiss with prejudice, or does that require something very specific, aka Alec Baldwin? Make me smarter. Yeah, it doesn't, just because you have a really crappy witness, the judge isn't going to dismiss the case, right? She's going to look at it. Is there enough evidence in a light most favorable to the Commonwealth that any reasonable juror could vote guilty? She's going to say yes to that. She's not going to dismiss this case. Netwoman, Peter, you have to check out the beginning of Attorney Melanie Little's live on Friday. Someone did baby AI with people talking about the trial. You're a star. Baby me is a star. That's funny. I'll have to check it out. Alessi stayed by the stand, so Hank Brennan couldn't sly help. I don't think that's what he was doing, but it's possible. Copy and paste, lies, and as requested by Mr. Brennan. Brittany, shouldn't defense use Burgess's education lie on Aperture website to broadly undermine their credibility as a company since those are the Commonwealth's key experts? I think they absolutely are. And I think they're going to say with Welcher, you needed Burgess and everything he did, right? And everything he touched sucks. They're not going to ask Welcher that, but that's the argument they're going to make to the jury. I feel like I'm screaming. Does the fact that Bev refused the voir dire him suggest that she might have known the defense wanted to show him to be unqualified? I don't think it suggests anything. I think she thought he's an expert, period. Now, did they let her know that he lied about this, or was this a surprise? I don't know. Was Bluetooth mentioned? Your car and iPhone are synced to the second. I don't think anybody mentioned that. Obviously, they're saying they were not synced. CJ, Peter, just want to thank you for your review and input for those of us who can't for whatever reason. Chloe did it. Peter, was all conversations with Brennan on the 8th and Trooper Tully okay to do unless he sounded like he was going to go after him for it? We're going to discuss that more. I don't know what you mean by conversation with Brennan. And well, Tully hasn't taken the stand, so we'll see if there's more to answer for, but he gives us some insight on what was talked about. Peter, have you had a chance to visit the Aperture website versus the ARCA website? One is clearly qualified engineers. The other appears not to be. I've seen ARCAs. I've not seen Aperture. So I'll have to check it out. Kitagi, if Rent an Expert was a person, a new documentary loading, Body in the Snow. In hindsight, the judge denying the voir dire was a layup for the defense. I didn't think it could get worse than Trooper Paul. Breezy B, is anyone going to ever mention the footage of the Lexus going up to the flatbed and the intact red light? They say it wasn't, but I do think that people were saying like the 3-point turn could have been when it was put on the tow truck. I think that they dispelled that theory today with this witness, so at least they did that. Christy, I would bet 5 lawyer memberships that Shannon is terminated from his firm before this trial is over. I'll take that bet. So if he still has a job, you're going to give 5 lawyer memberships. If he gets fired, I will give 5 lawyer memberships. I'm not going to hold you to that, but I will give it if he doesn't. Hi, Peter. Do you think Lally feels a bit better about himself seeing this disaster of the Commonwealth's case presented by Brennan unfold? I mean, I thought his was pretty bad last time, but again, he got 8 guilty votes if you believe the jurors. Mr. Lawyer, I know, and Emily D are the only people whose coverage I watch, but I have noticed you guys see things quite differently. Example on how good/fair Bev is. Would love to see a friendly conversation on the trial. I think we're going to make that happen. I don't know when, I don't know how, but I think we're going to make it happen. Tingles, having destroyed his character and attention to detail, do you think Hank will still try his second bite of the apple? How would you have rehabilitated the dumpster fire? I would say, did you testify you went to UAB on the stand? Do you tell people you went to UAB? Have you testified about that at any trial? Hoping the answer is no to that. Does that affect your ability to do this work? How long have you been doing this? Do they teach you anything about in your undergrad that you do this, or do you learn this by experience? That's how I would try to rehabilitate him. Peter Burgess is saying there was a backing event from 12:32 to 12:32. John's phone locked at 12:32:09. Not buying it. He did say 5 seconds before and after is kind of taken into account. At some point during the cross, could the judge have stopped everything and decided if voir dire was actually necessary? I've never seen that happen. Maybe if the lawyers asked for it again, but I've never really seen that happen. Chloe did it. Only my second super chat ever. How come he said everything was to the second, then final event, there was a 10-second window? Well, he says that the Lexus data to everything was the second, but it starts recording 10 seconds before and 10 seconds after. So if that's where it was kind of recording the event, I think that's what he means. But again, this stuff is kind of confusing. Experts are supposed to make it easy. You're not supposed to have other people explain it to you to make it easy, right? So what's the jury thinking? Adult Trail Pro. I'm Sarah, an EMR audit trail expert in med-mal cases and have testified at trial many times. I knew I was watching a man's career die. Sad, but also he did it to himself. No credibility whatsoever now. It's been brutal. But let's listen to, did I already get to the right timeline? Yeah, let's listen to some more of the tech stream reports and what changed from January to May.
In connection with the text stream 1162.1 and the 1162.2 events.
No.
But you didn't discuss that, meaning the 1162.1 and 1162.2 events in your first report on January 30th, did you?
That was not part of my report, correct?
But you did
Which is just crazy to me that wasn't even part of his first report.
delve into that and pretty heavily in your May 8th report, correct?
Correct.
And you delved into that pretty heavily in the middle of this trial, correct?
Correct.
So after the trial, you know the trial started around April 22nd in this case? Generally?
Yes, generally.
So let's do the timeline on this. January 30th, 2025, you prepared your initial report, correct?
Correct.
In that initial report, you mentioned nothing about text stream event 1162.1, correct?
Correct.
In that report, you mentioned nothing about text stream event 1162.2, correct?
Correct.
The trial starts April 22nd, correct?
Correct.
Russell.
Generally.
No, the trial in this case, this trial about April 22nd, after the trial starts and after witnesses, of course, are appearing, you prepare another report, correct?
Correct.
And that's your May 8th report,
Correct.
right in the middle of this trial.
Correct.
And again, the fact that he acts like this is no big deal. And just wait. He knows it's, and that's what I'm saying. John O'Rourke, You can say he's calm and like you think that's good, but he's saying this and eventually he's going to answer. This is the first time ever in 10 years that he's ever done this. Produced a report in the middle of trial. So he knows this is not how it's supposed to be done. Triple B, I don't know. She seemed to let Alessi go. I don't know. I don't want to give too much credit there, but I think she knows this is a disaster. I think she realizes how disastrous this is. Knowing just how bad this is, do you agree with the judge's decision to let this new report in and leave it up to Cross? So I knew that she was going to let the time change in, and I understand it. And this was the part that I kind of was like, I would just be prepared for this if I was the defense attorney. The bigger problem I had is letting Welcher split his testimony from their case in chief and rebuttal. That was the one that really made me lose my mind. And to act like this is not material. She can act like it's material, but say he's going to explain it and you can have it for Cross.
And right in the middle of this trial, you enlarge the number for the 21 to 29 range. That's bigger than what was in your first report, correct?
No, that is not correct.
Well, you changed the number, don't you?
No, I did not change the number.
Well, let's go back to see exactly what you did, sir.
Sure.
Let's start with the basics. You said on direct examination, sir, that you prepared your May 8th report on your own initiative. Those were your words on your direct testimony, correct?
Correct.
I'm going to read the first line of your May 8th, 2025 report.
Okay.
If you have it in front of you, sir.
I do, yes.
It starts, Dear Mr. Brennan. You see that?
Yes, I do.
So BLNR, this is a good point, and I think he's working his way there. I think he's got a long time left on Cross. So we're going to see. He does have to do that, right? Because just crushing his credibility might not be enough for some jurors. That's a real thing. It's a real thing.
Pursuant to your request. That's a request you're referring to, Mr. Brennan, correct?
Correct.
I have
Now he's getting into the fact that you said you did this on your own, but in your letter, it says pursuant to your request to Mr. Brennan. So did he request it or did you do it on his own, on your own?
completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
You're explaining the May 8th report in your language pursuant to your request as a cut and paste from a previous report?
Yes, I am.
And again, as nonchalant as can be, to take words from the Lori Vallow case. Yeah. Copy and paste, no big deal. I think you should say there are certain portions I do copy and paste, I shouldn't, and I'll stop doing it or something. You know, like show a little like care to be better than what is being shown right now.
Do you cut and paste important information from one report to the other without checking it for accuracy?
I copy and paste certain portions.
Do you ever review what you cut and paste to see if it's accurate?
Yes.
You didn't review it this time, though, did you, sir?
No, I did not think it was significant.
Oh, you don't think it's significant, sir, that the matter is in the middle of a trial and there's a request for a new report after testimonies occurred in that trial? You don't think that's important?
Objection. Sustained.
Objection sustained, but that's a good question. You don't think that's significant? The reason it was sustained is because it's probably compound and it's a little bit argumentative. He could really get into it if he needs to, but Michelle L., no way. No way. Like, in order for us to get tricked on something like that with a medical expert, they've got to be committing some serious crimes to be tricking people and have a practice and treating all sorts of people. And I mean, it would just be insane to think about. No way.
Why did you prepare the new report then?
Sure. So there was a claim from a PowerPoint presentation by Mr. DeSogra of trying to adjust clock syncs or making clock
Right,
adjustments.
so it wasn't Arca, it was this other expert. And he's saying he did all this because of the claims that he made. But what's wild to me is it's like, it seemed like you didn't even testify about anything that was in your first report. It seemed like you only testified about what was in your second report. It's wild.
Based on the synchronization.
Second report was really the only report that mattered. That's what it felt like after all is said and done, right? I mean, I know Welcher's going to use stuff from the other one as well, but it's just, I don't know.
Of certain events that was produced in March. Upon reviewing that, my initial thoughts were to address that in testimony. But as I was preparing for trial, I made the decision that it needed to be better addressed in a supplemental report.
That was a mistake. See, what he said right there is what I've been saying all along he should have just done. Address it in testimony. When you get crossed on it, explain the 21 to 29 second deal. Let Brennan deal with it on redirect. That's what you should have done. That's what normal experts do. Do not write another report. That is a problem. That's something that's really difficult to come back from, in my opinion, if I was on the jury, which I'm not, and probably not a lot of lawyers on the jury that'll think about it that way. But
you understand that the report that you're referring to, that's the report of Mr. Soger, correct?
It is a presentation of Mr. DeSoger.
It's a presentation. You understand his presentation merely was responding to the work that you did, correct?
No, that's not correct.
So your belief is that Mr. DeSoger's report didn't address at all what you had done?
Partially, yes, but no.
Okay, but let's cover the basics. You
Sure.
agree that Mr. DeSogra addressed, at least in part, the work that you had done?
He tried to address, yes.
Right. So do you know the date of Mr. DeSoger's report as March 5th? Does that sound right to you?
Yes, that's what
So
I said.
you had Mr. DeSogra's report that you claimed was the basis for you on your own in the middle of this trial, creating and submitting a new report. You claimed that the basis for that was Mr. DeSogra's report of March 5th of 2025.
That is correct.
You waited 2 months to do that?
Again, my initial thoughts were to address it on
My
testimony.
question, sir, is not your thoughts. Just, did you wait 2 months?
Just let him finish the answer.
My question, sir, and finish it how you like.
Sure. So
2 months, was it 2 months between March 5th and when you submitted your report on May 8th? Is that 2 months?
yes, it is.
So did you know when this trial was going to start, sir? Generally?
Yes.
Do you think
he had all the information he needed for months and months and decided to do it in the middle of trial. And again, this is my job, right? Like, that's why I think maybe it bothers me more than some people, because I know like discovery deadlines. I mean, we've seen a Rule 14 violation and public reprimand, and we've got to figure out what the sanctions or remedies are going to be. It's like, but then we can just do something like this. And he's like, no big deal. He's never done it before in his career. That should tell you something.
it's fair to submit a report without anybody asking you in the middle of a trial?
Sustained.
As we've been discussing, you
Spencer Green, we know that not all LinkedIns are legit, so we'll have to check it out, but it doesn't mean you could have just changed it. It could be out of date.
issued a brand new report, in this case dated May 8th, 2025, correct?
Correct.
That changed your analysis, correct?
No, it did not change my analysis.
Were there changes to your analysis in it?
There were clarifications.
Clarifications.
Correct.
Misinterpretations and clarifications, not misunderstandings or incorrections, and definitely not changes. Those types of semantics and language changes to me, that's a tick to me. You lose credibility. Okay. And that, I mean, there's just, and I could be at this point biased against this witness because of the damage done to his credibility at the beginning of cross. So that is possible as well, where I'm nitpicking everything he says and just being like, I just don't think I can believe this guy. And like some of the other comments said, he's got to get to those connections and breaking down their timeline, but also he's crushing his credibility so bad that maybe it's working in more ways than one. Thank you, Netwoman, for gifting 50 memberships.
Let's address that. In your January
Yes,
30th,
Trish.
2020
Same, Trish. Same.
25 report, you did not mention text stream event at all, did you?
No, I did not.
And you didn't mention collision at all, correct?
No, I did not.
And you mentioned both of those now in your May 8th, 2025 report, correct?
I don't know if I've mentioned collision. I'd have to go to my report and look.
But you certainly do mention text stream events, correct?
Yes, that's
and
correct.
you labeled them 1162.1 and 1162.2, correct?
Correct.
That's a change from your first report, isn't it, sir?
No, it's not a change. It's a supplement.
Oh, so your definition is that when you add something to a report, it's not a change, it's a supplement?
That is what it is. Yes.
Who did you speak to regarding the May 8th, 2025 report before you prepared it?
And no one before I prepared it.
No one. No one before he prepared it. Thank you, Rebecca, for gifting 10 memberships.
So you just prepared it on your own.
I did.
Did you have any communications at all? I asked you who you spoke with, but did you have any communications at all with either Detective Lieutenant Tully or Buchanan?
So I did reach out to Tully to get a full set of the location data. Yes.
So you reached out to Detective Tully before you prepared your May 8th report, correct?
Yes, that is correct.
Did he tell you that the trial had started in this case?
No, not during that conversation. No.
That's not the first communication you had with Detective Tully, was it?
No, it's not.
How many conversations have you
He also talked to Tully. Thought he talked to no one.
had with Detective Tully?
I would say a handful.
How much is a handful?
I would be speculating, but we'll say 5 to 10.
5 to 10.
Sure.
Is Detective Tully expert at all in digital forensics?
No.
But you've had 5 to 10 conversations with him.
Correct. To get provided information.
At any time, has anybody from the Commonwealth had a discussion with you relative to your January 30th, 2025 report or your May 8th, 2025 report about keeping flexible the timelines for any events in this case?
No, sir.
Did you have any discussions at all regarding the May 8th, 2025 report you prepared in the middle of this trial with anyone from the district attorney's office?
Yes.
When did you have
He
those?
literally said no 2 seconds ago. And now it's Tully, Hank Brennan, and Dr. Welcher. Okay. So this is the big question a lot of people have asked. So Ryan is saying, is the delayed second report at Brennan's request not trial by ambush? So he said Brennan did not, in fact, request it. There were a couple other questions I'll throw up there as well that people are asking, like, did Brennan lie to the court? What's the court going to say about Brennan lying? Brennan did have a chat with him. Will Brennan have a chat with him so he's better tomorrow? Not allowed to talk about a testimony, and I promise you Alessi will highlight that if Brennan tries it. That's a major problem, right? If Brennan does talk to him before. But did Brennan lie to the court? Did he know about this prior? Was he not surprised to learn about this report? Let's listen to what this expert has to say, and then I'll give you my opinion.
Those discussions.
That would have been on, probably May 7th when I reached out to Mr. Brennan.
So you reached out to Mr. Brennan on May 7th, 2025, correct?
Correct.
That's before May 8th of 2025, correct?
Correct.
So before you sent that report in, you had a discussion with Mr. Brennan about it, am I correct?
Correct.
What was that discussion about?
That was just a discussion over the data. The report said.
So you were discussing with Mr. Brennan what was going to be in your report, including data and analysis, correct?
Correct.
Yikes. You were discussing that. Now, here's what I will say. I think this is what the judge is going to find. That Hank Brennan was surprised by the May 7th call about the report that was already prepared. He talked to him. He ended up doing the report on May 8th, and no harm, no foul. He knew about the report. He did not request it. Anything that says he did request it and all that they've already talked about, the witness on the stand under oath has already said, I did it on my own accord. I prepared it. Nobody asked me to. That was a copy and paste problem. Pterodactyl Peter, wouldn't it help just a tiny bit to have the tow truck driver testify? SUV backed 60 feet, could be backing off the tow truck. I think that they have proven that's not the time that this happened, but maybe if it is, then maybe. And Tully didn't think to mention that to Brennan. Yeah, Tully really is feeling like he's coming out like a villain big time, right?
Did you tell Mr. Brennan that you were going to be submitting the report shortly to him on May 8th?
Yes.
Did you agree to a time when you would submit that report?
No, I did not.
Did you tell him when you were going to submit it?
No, I did not.
But after the conversation on May 7th, you discussed with him that you had either pretty close to finalize the report. It's a pretty extensive report, right?
Correct.
So on May 7th, you were pretty well along the way in that report, correct?
Correct.
Did you let Mr. Brennan know that?
Yes.
So he knew the nature of the report. He knew how far along we were with it.
Correct.
I do think the defense is going to argue he knew about it and he wasn't surprised because he knew the nature of the report. He knew he was doing it when he said it was a surprise. Now, I would have to go back. If Hank Brennan said, I was surprised on May 8th, he's dead in the water and the judge better reprimand him. Do I think he's going to? What are Bev's grave concerns about this guy? 2 days of voir dire for PhD crash daddies and Dr. Russell, who Bev feels was barely qualified. That's the problem. When you say stuff like that in orders, it comes back to bite you when stuff like this happens. Now, they're two very different specialties, and you need very different educational backgrounds for them. But oh boy, some of the hyperbolic language can really come back to bite you.
Did you have any other calls with anybody from the prosecution's office other than that about your May 8th report?
No, I don't believe so.
Do you have any texts with anybody about your May 8th report?
No.
Did you communicate with anybody else about your upcoming May 8th report?
No, I would have provided a copy to Dr. Welcher.
Your colleague?
Correct.
So Dr. Welcher knew you were working on this report, correct?
He knew I submitted the report.
So it's like turn 0 people turn into 3 people real quick.
I don't know if he knew I was working on the report.
Did he know you were going to submit the report before you submitted it?
Yes, I'm sorry. Yes.
Did he know what was going to be in the report?
Yes, he did.
Did he support the fact that you were going to submit a report in the middle of trial?
I can't speak for Dr. Welcher.
But he knew you were going to do it.
Correct.
Did he say anything, don't do that? Or did he have any comment about the fact you were going to submit it?
Not that I recall off the top of my head.
Not that you recall, so is it possible he did comment on whether you should submit it in the middle of trial?
No, he would not have commented on whether I should have submitted it or not.
How many times in your career, sir, have you submitted a supplemental or amended report in the middle of trial?
This matters. This was a great question. This really matters. It's like you're acting like this is no big deal. Tell me another time you've done this.
This would be the only one that I recall.
So this is the only time. How many years have you been doing this?
Approximately 10 years.
And so approximately 10 years, this is the first time you've submitted a amended supplemental report in the middle of a trial.
A supplemental report, correct.
As you call it, a supplemental report in the middle of trial.
Correct.
All right, we're going to jump ahead a little bit here to talk about more of the timing on the text stream data. This is going to be kind of the last section we listen to. Let me hit some more questions here. So why would the Commonwealth put this guy on, knowing what the defense knows, about to wipe this expert across the coals? They already had him. I would assume they didn't know about it when they hired him because they didn't do good enough research and they felt like they needed what he was going to testify to. It was a mistake, in my opinion, but they did it. Again, trying to explain why somebody makes a mistake is often difficult, but I find myself trying to do it all the time. Spicy Burrito. Congrats on being the number 16 podcast on YouTube. Amazing. On Rogan's Tale. That was so wild. I don't know if anybody else saw that, but that was so crazy to see when people were sending me that. Hit the like button if you guys haven't, and please make sure you subscribe. We are this close to 500,000 subscribers, hoping to get to it before the end of this trial. Tingles. The best courtroom massacre. Camille has nothing on Alessi. Wow. Have you ever seen something like this throughout your career? Who do you think got it worse? Him or the credibility of his company that preaches pursuit of truth? Definitely him. He personally is going to take the brunt of this. Becky, how does this affect the cross and the trials that he has already testified to as an expert? Would this not cause a lot of legal issues for his company? Only if he lied under oath. I've answered this question a couple times, not just because of some work he did. It's going to have to be material to what he did. Ryder Kitty, how can this witness be so calm on the stand after all this? Alessi dropped the mic. I agree. And by the way, it could absolutely affect other cases. Absolutely would affect the way he's cross-examined. It just wouldn't automatically overturn other things he's done. Michelle, Hank submitted the CV to the court. That was not truthful, though. Does he not hold any accountability for vetting his experts before submitting them? So 2 things on that. Partially, yes, but you don't have to go do this kind of research. If your expert lies, you're not automatically, sanctioned, number 1. Number 2, the expert had an explanation. It was outdated, and those were when I planned on completing my bachelor. So it is what it is. I get the issue. I get the problem, and I would be screaming from the rooftops about it too. The judge admonished the jury about not making faces during testimony, but John's mom sits in the view of the jury and rolls her eyes and makes faces. How is that fair to Karen Reed? If the defense thinks there's an issue, they should ask the judge to instruct her not to. It's obviously touchy, right, as the mother of the victim in the case, but it can make a difference. Norman's dad. If this was an initial trial in another state or in Massachusetts with a different judge, would it have a chance of being thrown out by a judge based on the case so far? Not based on this testimony. This is what is supposed to happen. It's supposed to feel like a bloodbath with the lawyer on cross-examination if this is how it's going. Kraken Studio. In my opinion, Bev can no longer claim non-bias. Hank lies are blatantly obvious, yet accepted as fact, then held against the defense without. Bev breached complicity. To me, she is allowing robust and broad cross-examination. We'll see how she deals with the problems coming up with this expert. Commonwealth uses qualifications to stop of voir dire. Education and experience. Frankly, even without his BS, I think he's qualified to testify about this stuff. I do. Taylor, Was this expert, based on his resume, right? It could other stuff could be lies. I don't know. I haven't done the vetting myself. Was this expert the D requested of voir dire for last week, and HB opposed it, saying he was acting in good faith, asking for one? I don't remember. Judy V. Bev said she was going to give Alessi a lot of leeway. Were all these proper questions, or did she actually give him a lot of leeway? They were proper, but she did give him a lot of leeway. The government does conduct background checks for individuals working on contracts, which must have been overlooked by Aperture FBI. Yeah, I wonder why the federal government didn't hire these guys as their experts. Thoughts on Bev scolding HB like she did the defense? Highly doubt it, but I think it would be warranted. Kurt Smith. Bev voir dire Arca multiple times, but this guy takes the stand while misrepresenting his credentials. No questions asked. How does that make sense? It doesn't. It's brutal. It makes everybody look bad on that side. But it also was like an amazing day for the defense. So it's almost like a blessing in disguise. Apologies if this was already answered, but does the due diligence sit with the defense prosecution fact-checking credentials for their expert witnesses? Yes, but only to a certain extent, right? If it wasn't obvious, if it wasn't easy to find out, if the guy's just willing to lie to you, then there is some leeway there with like, what are you supposed to do, Judge? The L21, I mean, I would be thoroughly embarrassed if I picked this expert. Can Alessi also cross Welcher on a CV since he is executive VP of Aperture? Ooh, that's a good point. Did you have any hiring decisions to deal with this guy? That's a good question. I don't know the answer. I don't know what his duties are. Touche. Has Hank gotten so focused on winning that he's gone nuts? His ethics and moral compass were never good enough for a prosecutor. Okay for poking holes, I think. But where is his judgment with his choice? I don't know what he knew, right? I don't know what he knew. I wish I knew what he knew about this. I feel like it's worth it for the judge to have a whole separate hearing. Like, Brennan, did you know about this? You putting this guy up with this resume? But he didn't ask him the question, which is partially shady, partially not suborning perjury. His face is purple. That was about time I thought he was going to have a medical emergency. Brian, is a reasonable degree of legal certainty beyond a reasonable doubt? Not if you're like a legal expert. To reasonable degree of legal certainty would be like, what are appropriate legal fees or legal standards? But I guess this is one way of looking at it. East Bay Thunderdunk. Is it possible for the case to be pushed by the higher ups? Only thing that makes sense to me, should I take my tinfoil hat off? This is not one of those things. The remedy for this is you get to eviscerate them and embarrass them on cross-examination. That's how you deal with the problem we're looking at now. Ronan O. What gave Brendan the confidence in this guy not to voir dire? Did the defense strategically not request one? I think they did request. There's so many. I can't keep it straight. I don't want to be the bearer of these facts and details. So you guys are going to have to discuss that in the chat. Peter, this guy's not smarter than you. Also, can the judge strike this guy because of his lies? We all know she won't, but is it possible? I'm still stunned. He didn't lie on the stand, right? He's giving reasons why his resume is misinterpreted and there are errors, but he didn't say this stuff on the stand under oath. Dude just asked if 2 gigabytes was equal to 250 megabytes. No. Storage on devices like phones, etc., are never measured in gigabytes. Transfer speed are measured in bits. I wonder if there are jurors that have that kind of technical knowledge. Please say hi to my husband, Dave. What's up, Dave? Listens to you every day while driving his UPS truck. Awesome. That's a great job out here. You make his day go by quicker. Gringa. Peter, should the defense harp on the DA doing such a poor job vetting this expert? No. Again, I'm just telling you how I see it now. I think a lot of lawyers do is this is what you do. What Bob Alessi is doing, this is what you do. Valerie, thank you for your recaps, Peter. Celebrating my husband's graduation on Friday at age 58. He's now also a listener. So he can put, he graduated in 2025 and it will be not an outdated resume entry. Why was his late submission response done to questioning one on the Dr. Pierce area? I think they sacrificed this guy. I'm not positive what your first question is asking, but it definitely is not good for him. Peter, the Commonwealth's original theory was that Karen Reed hit him doing a 3-point turn. Now John O'Keefe was in the car for the 3-point turn. Did anyone talk about that? I think they're going to try to get all of these competing theories out with Welcher, using Trooper Paul, using all the stuff that was testified to in the first trial. They have to do it a very specific way to make it admissible. Okay, let's jump back in and listen to the last part of the testimony I want to hear before we sign off for the day. You guys are the best. This is a ton. This is the longest stream we've done so far. And also almost 40,000 people in here, which is crazy. So if everybody hits the like button, we could get to 30,000 likes. I don't think I've ever had 30,000 likes on a video. Let's make this one that video. How can he not be held in contempt? Again, he's not lying on the stand. He's admitting errors in his resume. So there is a difference, but I get why people are appalled, and I'm with you.
Sir, you now have what is in evidence as Exhibit 188 for identification. I draw your attention, and this is the slide that you considered in responding to Mr. DeSogra, correct?
In response to Mr. DeSogra's analysis of this slide, yes, correct.
And this slide, to be clear, is a slide prepared by your colleague at Aperture, Dr. Judson Welcher, correct?
Yes, that is correct.
Sir, could you please read the time that Dr. Welcher states for the when infotainment trigger 1162.2 occurred?
So that would be extreme trigger, just for clarification, but yes, I can.
Well, let's go to that. You use the parlance text stream trigger. Dr. Welcher uses infotainment trigger, but it's 1162.2. You both use 1162.2, correct?
Correct. And I think that may be a misunderstanding of how he's worded it.
Well, Your Honor, I'd actually move to strike that about what Dr. Welcher, I'm just going to what the document says.
I'm just going to leave it, but go on.
Thank you, Your Honor. So the document says that the infotainment trigger 1162.2 occurred at approximately 12:31:38, correct?
Correct.
And that it ended at 12:31:43, correct?
Correct.
So we've got the trigger, according to Dr. Welcher, as of recently as January 30th, 2025, starting at 12:31:38 and ending at 12:31:43, correct?
Correct. According to the Lexus clock.
Right.
Yes.
So now let's go down to what says below. Per report from Ian Whiffen, O'Keefe's cell phone data showed, quote, most notably, all device lock events, including the final lock event at 12:32:09, were user initiated by the user pressing the side button briefly. You see that, sir?
I do.
And did I read that correctly?
You did, with the caveat that's according to the iPhone clock.
Right. But in any
And he's got to make sure to make those distinctions, but he's running through exactly these changes, why they're so important. And I think he's got more coming, right? This is right at the end. Hank definitely said he was surprised to get that report. I'll have to watch the timing because was you surprised to hear about it? To hear from him, it's going to be important to parse that out. On a scale of 0 to 100%, what percent do you currently believe Karen will be found completely innocent? 0, because that's not what juries do in the American criminal justice system. If Tully knew this guy was doing a report, does that mean that Hank knew or should have known? So I don't know, did he say exactly the date he told Tully he was doing the report? Because he did say he told Hank as well. So Hank did know one day before the report came out. How much was this so-called expert witness paid to testify for Hank Brennan? So unless he asked him those questions, he didn't know the answers. I assume we're going to get that information sooner rather than later.
event, that's what Dr. Welcher states on his slide, correct?
Correct.
Do you know, sir, that the iPhone data reported by Mr. Whiffen that you read, that Dr. Welcher references, do you know that report of Ian Whiffen says there was an end of a health event of 36 steps covering a distance of 84 feet that ended at 12:32:16, which is after 12:31:43?
Yes.
And you know that?
Yes, with the caveat those clocks have not been adjusted.
But you know that there was a...
Unless he did stutter, because again, if he would have just testified about this and didn't have the college stuff, I think they could have a little bit of a discourse about, what this time means. Could he technically still be correct? Now, I don't know how after the correction, how is it possible that Karen Reed gets to John O'Keefe's house by 12:36? I still haven't figured that out.
End of health event of 36 steps covering a distance of 84 feet that ended at 12:32:16, which is after 12:31:43, correct?
Correct.
Just stating the comparison. So now what I'd like to do is to move on with regard to the analysis. So, and Dr. Welcher wrote the slide he presented, it's dated January 30th of 2025, correct?
It's not dated here.
It's not dated.
Yes.
Do you know that Dr. Welcher created a report of January 30th, 2025?
I do know he created a report. Correct.
Right, and that's the same date as your report, correct? Your
Correct.
first report.
Correct.
So you both submitted your reports on the same date. They're both dated the same, at least, correct?
Yes, if they're both dated the same, yes.
Yes. Are you familiar with the concept of pocket state in iPhones?
I am.
And he's going to keep digging basically here. And this is right where it's about going to end. And you have to be careful about how much you're going to apply of Ian Whiffen's report and knowledge to this guy, because he's not going to know everything Ian Whiffen did. And that's what some of these objections are for, because everybody asks because they can't explain them. And when they go up to sidebar, that's what these objections are about.
Familiar through Mr. Whiffen's report.
Okay. You said you've read Mr. Whiffen's report, correct?
Correct.
So you know that Mr. Whiffen states that there was a pocket state detected on the iPhone of Mr. O'Keefe at 12:33:14, correct?
Objection.
So the same, I'm going to strike it, do it the same way, Mr. Alessi, okay?
I will, Your Honor. Thank you. Are you aware?
If the report wasn't requested, could Hank Brennan have said no? So I have a feeling that's probably how that conversation went. Like, I don't have to submit the report if I don't want to. Do you think it's better for it to be a report or for me to testify about it? Those are conversations lawyers and witnesses have. It's possible that happened here. Do you think Hank Brennan thought this guy was his ace in his hole? Oh, I sure hope not. I don't think so, and I hope he did not. Peter, if this was your witness, how would you attempt to recover and save him during your recross or redirect, I think you mean, or would you even try? Yes, I would. And Christy asked the same thing. I would try to get back to the data and say, you know, your resume has had errors on them. Does that affect how you did your work in this case? Do you learn more from your education or your experience and what you do here? You've been doing this for 10 years. You have your AA. Like, I would try to rehabilitate him like that, get back to the data, and try to show how this all lines up with our theory of the case.
Of whether Mr. Whiffen has put in the report you read a timestamp for detecting pocket states of Mr. O'Keefe. Are you aware of that in the report at all?
I am aware of that in the report, yes.
Do you know when Mr. Whiffen has noted a pocket state detected of Mr. O'Keefe's phone? Do you know?
So, Mr. Alessi, why don't you show it?
That's what I was going to do. I will, Your Honor. And if we could put it, we've got it. That's already in evidence on screen.
Okay.
It's already in evidence in
So
screen.
are you talking about Mr. Whiffen's report? Or
Correct. The one. Well, you know what? I'm going to show him the report, Your Honor. I'll do it the way you suggest. Sir,
This is basically where they end the day. This is basically where they end the day, is on this discussion, and this is where they're going to pick it up tomorrow. Cheswick, is it possible for this witness to plead the fifth tomorrow and just elect from further examination embarrassment? No, I mean, he hasn't lied under oath. He's not committing crimes on the stand. He's embarrassed, and he's maybe, you know, going to lose his job and potentially lose some contracts, but I don't, he's not going to plead the fifth because he's not testifying to anything that would be incriminating here about what the work he did on this case. Do you think this will be used in law school to teach aspiring lawyers to vet their experts? I think it's a good example. And I think that's what's great about these YouTube cases and stuff being streamed is everybody can watch and see and learn. Patricia, if the Commonwealth doesn't call Proctor to testify, can the defense make him testify because he has been mentioned so much or keep the jury guessing? Yes, the defense can. Will they? We'll see. I think they will. Catching up here, but Burgess said he got his associates in 2015. How did he start his bachelor's in 2008? Could be the first class, right? Then you 2 years to get your associate, or it took him 7 years to get your associates, and then, you know, another 10 to work on his bachelor's. Eli Apple. Peter, for us non-lawyers out there, how does the Commonwealth even find an expert like this? Do they cast a wide net with a predefined theory and see who agrees? Not necessarily. Like what I would do is I ask, if it's an unusual expert I've never had before, I ask my colleagues and my buddies that I trust that have worked on these cases, or I ask experts I've used. There are also groups that maybe we've used a reconstructionist expert and they'll have a line of sight expert there or whatever, you know, and they'll know, experts will know each other. So you start with the network and people you trust usually to get a referral. Besides Arco, who do you think the defense will call? Dr. Russell, probably Proctor. I think they're going to call a ton of people. We'll talk about this on a future video. What, if any, sanctions could be imposed on the Commonwealth for this? He is saying they knew, and Hank Brennan represented to the court. He was surprised to receive it. If Hank Brennan lied to the court, there should be some kind of sanction. We need to get the specific language he used to prove that, though. I've got to go back and look at it. I have not, as I sit here today. I have to go. I'm going to be late. 7 o'clock, NBC 10, Boston. I'm going to be on there tonight, so everybody check that out. Aperture changed Burgess CV again this afternoon, not for expert designation. Can this be brought up in court? Absolutely. But I think they said everybody says that on LinkedIn, but I don't know. I'm confident the defense goaded them into making this happen. This is close to the glove, doesn't fit moment. Cocky, Brennan keeps underestimating. Well, they said they looked at it 72 hours ago, and then he removed it. So that's interesting. Kenzie's logic. I just got here, and the first thing I wondered is, was his face red when he sat down? I don't know. NCDAO is 1 hour from MIT and hired experts with no degree. I have hired experts with no degree who have been awesome. Think about like my cousin Vinny, right? You're the best, Peter. Thank you for your expertise. Thank you. Jay Lookout. Aperture has his CV watermark, not for expert designation. What are the reasons they would mark it as such if he was used as an expert? I don't know. People have said that that's on a bunch of theirs, so I've got to go look. That's something that happened during the video. Burgess CV, not for expert designation. It's amazing how many people are sleuthing now, right? And you guys are going to go look. And I mean, this is why this is not good for him, obviously. Not good for the Commonwealth. After 5 years of classes, don't count. He lie, just admit it. Thank you, Susan, for gifting 5 memberships. We can pull this down because I am out of here. It's now gone, people are saying. This is so wild. Tingles, Peter, if you had to rate this cross, what would be your rating be? Have you had moments like this? Please spend a lot of time with Papa T on this one. Oh, I'm sure we will. I would rate it a 9.2 so far, and we'll see. It could get better. I have never had an expert lie about their credentials to this level. No way. Just finished 6 months on a grand jury. Staying neutral was tough at times, especially when testimony included suspicious or clearly false information. Ooh, Danny, I'd love to hear about this. Send me a DM if you want. If you're able to and you're done with it, I'd love to hear about it. Alessi is a Mile Orden type, and most of us had perhaps never heard of him. Could he perhaps be enjoying getting positive recognition worldwide? Could you imagine? I hope go Alessi go. Oh, absolutely. This could be the highlight of his career potentially. And a lot of people have never heard of him before this. Idiot Wind. Collusion in the prosecution, lending credibility to the defense conspiracy theory. There's at least a suggestion of dishonesty. So will she at least demand all comms to make sure he didn't request it since it's so suspect and all Hank had was hunches. Here's my beef with it, okay, Idiot Wind. The big deal about Signal app and deleting of text and blah, blah, blah. Well, what did we hear? Hank Brennan talked to this expert on the phone. What are we never going to get? The content of that information. So the most we're going to get is people telling us what they talked about. So what's the difference? And this is how it's always been dealt with experts. Bev gave Alessi a lot of leeway when he asked the witness if he knew about mendacity. Ment didn't admonish him at all. Again, I do think she's absolutely giving him leeway. Okay, I got to go. You guys are the best. Hit that like button, subscribe, all the stuff. Cross is going to continue tomorrow. I will be back tomorrow to hang out with you guys. You guys make this so energizing for me. So I really appreciate it. I love talking about the law, love talking about these cases, and we will continue to do so. But for this time, it's all we got. Till next time, peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.